Hello, fellow Toolboxers. Thanks for joining us. This episode number 375 of the Immigration Lawyers Toolbox podcast. It's going to be a really neat one. I'm going to enjoy getting into these more and more. One thing I do since I started, practicing immigration law is I try to go read the Foreign Affairs Manual, the Policy Manual, the Former Adjudicators Field Manual, and also INA, and most important probably is the CFR, the Code of Federal Regulations. There's a section 8 CFR. Most of the immigration stuff is in 8 Code of Federal Regulations or CFR. And so there's other sections that touch it, but it's really good to go back and check it. And in this podcast, I'm taking 7 particular notes that stood out from 8 CFR 103. 8 CFR 103 is about the USCIS filings and what could happen what things that are, well, you'll see. Top 7 things I've marked about USCIS filings that you should be aware of that you may or may not have known that you may or not you can do. So that's going to be really fun. I recommend listening to this one and get to know it a lot. It also kind of shows the analysis level we do in my marriage green card course for those wanting to become immigration lawyers or starting a family-based practice to do it the way I do it. The course is reminiscent of this, where you read the CFR, the INA, the policy manuals, the memos, and stuff like that. You get really good at immigration law to do a really good family-based practice and take things to the next level. I do also want to thank our sponsor for this podcast, the sponsor for the recent magazine that we published, MetroTech. MetroTech's INA Zoom is one of the leading softwares in the space. Are you tired of sinking your most valuable assets into tedious data entry? Then it's high time to streamline your immigration process with MetroTech INA Zoom, the leading immigration case management software trusted by top law firms and corporations worldwide. MetroTech INA Zoom helps you manage cases, track deadlines, and automate workflows so you can focus on what matters most to your clients. But that's not all. MetroTech INA Zoom just launched GovNotice IDP, a revolutionary AI-powered tool that automatically extracts critical information from your government notices and receipts. No more manual data entry, errors, or headaches. Instead of traditional and highly time-consuming manual entry of USCIS notice data, GovNotice IDP automates the entire process, ensuring a faster, more error-free experience. Legal teams can upload batches of receipts in bulk with automated classifications and case linking, reducing processing time significantly. Incredibly high accurate with hundreds of notices processed per day, options for automatic email notifications to internal and external players and stakeholders. And also, it supports USCIS receipt notices, including pre and processing, and approval notices. With GovNotice IDP, you can process and manage your case faster and more efficiently than ever before. Ready to elevate your immigration practice to the next level? Learn more at hrc.metratech.com/toolbox. Again, that's hrc.metratech, metratech.com/toolbox. Use that link so they'll know we sent you. Having said all that, the following information is not intended as individual legal guidance. Please consult with an immigration attorney about your case, but you know that all already. So let me get my notes. This is 8 CFR section 103. A lot of neat little things that popped up. Some I knew, some I didn't know that I think would be helpful. So tip number 1 from 8 CFR 103, and I just lost my place in what I was doing here. So here it is. Okay. So I got to move. I put my stuff in Notion. It's an app, but I have like 10 windows within Notion open. Always 50 windows open on everything. I'm not going to be sharing my screen on this one. So if you're listening audio, it's not a big deal. But the first one is you have a right to inspect the record. This is 8 CFR 103.2B16. Unless there's a national security or classified information, your client is entitled to review the very documents that form the basis of USCI's decision. So you could ask him and say, hey, I want to see what was in the record that made you make the decision. You can make that request under this section. Number 2, only one filing allowed while a case is pending, when one case is pending. So it's under ACFR 103.2A74. USCIS may reject duplicate filings at their discretion. So, it says that, but I've done it before and it works. So I think it is a discretionary thing. The situation I had is people had filed an I-130, and this is back when it was hard to change, and probably still hard, where if you, on the I-130 list, you're doing adjustment of status, but you really intend to consular processing, they say now you could contact USCIS and change the case for consular processing. But to be safe, in the past, when people come to me when they did that, I say, okay, we'll file another I-130, this time for consular processing. So essentially, we have 2 cases on the same beneficiary pending. I'm not sure if I say because it's consular versus adjustment. Maybe that's the difference. I don't know. But we do it as a backup so that's there. And this saying one at a time. So I don't know. I'd be hesitant now. I read this. I'm hesitant, but I've been done it successfully. So I think it's more of a discretion thing. Number 3, fee payments with checks over a year will be rejected. 8 CFR 103.2A724. Be very careful. Right now it's April, I'm recording this, but usually January, February, your fingers are used to signing the checks with 2024 as the address. Now it's 2025, and you put that 1 year off, it's going to be bad. So if it's over a year, honestly, I've seen it been rejected over 6 months, but under the CFR, it's over 1 year. Number four, USCIS can withhold adjudication of applications for investigations, but must review every 6 months. So under 8 CFR 103.218 B18, you have a right to have the decision reviewed or what's going on every 6 months. So you can always contact them if there's an investigation going on and say, hey, what's going on. Now, internally, they could just say, we need more time and just refresh it for 6 months. So it's one of those things where it's like, it sounds bigger than it is, but I was surprised that they actually have that in there. Number five, USCIS can deny without issuing an RFE if initial evidence is lacking. So you rarely see this happen. Maybe on Trump administration it'll happen, but under 8 CFR 103.2 BA2, they can straight up deny a case for lack of evidence without giving you a chance to even fix it. So you want to be as strong as possible nowadays, file the case with the medical and everything like that. I've had people now that have the rule where you do an adjustment of status and the medical checkup is required with it. Someone told me they filed it and they just got an RFU for the medical, so it wasn't as strict, but you can imagine under this situation that we're going through, it's going to get worse. Number six, USCIS can require testimony and must give a copy if requested. So under 8 CFR 103.2B7, if a testimony is taken, you could assert and request a copy of that testimony for your records. You should always ask for it, especially like if there's testimony taken at the end of like a marriage interview or something like that. There's some issue. You say, hey, I want a photocopy of what you wrote down there and signed and all that kind of stuff. Number seven, board and precedent decisions bind DHS USCIS officers. This is very important. ACFR 103.10B. And the reason why it really comes out, because I've heard opposite in my career, and I never looked to see what the statute was, which way it goes on it. Because for me, it pops up in this situation of this blasted so-called made-up 90-day rule, where they say, oh, if you come enter the U.S. and then you get married or you file for a green card within 90 days, this preconceived intent, immigrant intent, it's going to be a fraud finding. But in matter of Cavazos from 1980, it says notwithstanding evidence establishing preconceived intent, an applicant for adjustment of status shows general will be granted in the exercise of discretion in the case of an immediate relative. So that's a parent of a U.S. citizen, spouse of a U.S. citizen, or minor child. Barring, I'll just paraphrase it, negative factors where it shows actual fraud, like you fraud when your notes and to CBP you straight up lied, or your documents you straight up lied, or something like that, or you have criminal history, negative factors. But for the most part, this works. Now, people would say, oh, Matter Cavazos was a BIA decision, so it binds immigration court, but not USCIS or something. But here I found the actual regulation, 103.10B, that board and precedent decisions are binding on DHS. So if that situation came up, you could throw Matter Cavazos at them. Just make sure it's an immediate relative case and the person has positive indicators. But that's what the court has said, and they got to go it's binding on them. Now, in practice, I've never heard of actually everyone being denied. When you go to forums, both immigration lawyer forums and people filing their own, they make a big deal of, 90-day rule at USCIS is going to, and I've seen some bad immigration guidance from lawyers, like well-known lawyers, and they'll come to consult with me afterwards. I'm like, that's garbage information. But they got married within 90 days, and then they're like, oh, just leave the U.S. You did fraud and this and that. I mean, if there is a fraud accusation, might as well stay here, do adjustment of status, file 601 rather than go outside, wait for that 601 to happen, wait to do an I-824, all this kind of stuff. If that I-130 adjustment is pending. But just Matter Cavazos is Matter Cavazos. It's been law for 40 years now, and they haven't undone it. So something important to know, and I thought I'd share that. Thanks so much for listening. If you're interested in this kind of analysis of immigration law and you want to you're an immigration attorney or become a better immigration attorney, contact me at our marriage green card course. Emails info@immigrationlawyerstoolbox.com. We also have 1-hour sessions on business cases, E2, L1, NIW. The last E2 is coming up this April 17th, Thursday, 10 a.m. Pacific time, 1 p.m. Eastern, where I spend an hour going through and piece by piece of a case and seeing what's going on, taking questions in a small live group of lawyers. But we're going to stop E2s and move on to other categories. So if you want to get in on the last E2 session, hit me up, info@immigrationlawyerstoolbox.com. I'm immigration lawyer John Khosravi. Hope to see you all this summer at AILA National. I'm going to have a booth there as part of the Immigration Lawyers Toolbox. Hope to see you then. Bye-bye.